Okay, a very good afternoon, everyone. Hi, thank you so much for coming to join this session on corporate accountability, climate change, legal risk, and the environment. It's really a pleasure to have you with us. I know that this is a session right after lunch, so maybe everyone's a little bit lunch coma-ish. But thankfully, we have some excellent legal professionals in the house who will be providing their insights on this topic. So let me just briefly introduce your presenters today and who will be discussing later in the panel discussion. So I am Elizabeth Wu. I'm an international economic lawyer focusing on environmental justice and sustainable development. I work as a legal consultant with international environmental law NGO ClientEarth. ClientEarth sues companies and governments in Europe but tries to work with them in Asia. And I'm also a global fellow with the Center for International Law with the National University of Singapore and the Center for Environmental Law, where I look at international investment law and international trade law reform, as well as the interface between corporate law, climate change, and international economic law. I'm very happy and proud to be joined by Puan Janet Looi, who is a senior partner, head of corporate and co-head of the ESG group of Skrine, and also Mr. Q Jia Yao, a sustainable development lawyer and partner of Q & Co, who has really been pioneering sustainable development in Malaysia. He is a fellow of the Academy of Sciences Malaysia and the chair of the Malaysian Bar Council's Environment and Climate Change Committee. And fingers crossed, we may have an additional fourth presenter who, as a surprise guest, but just keep our fingers crossed. That may or may not happen. But if that does happen, we will just I will just change the discussion format accordingly. So no worries regarding that. So without further ado. What we're going to do is basically set a brief overview on different forms of global trends in litigation as well as developments relevant for corporate accountability. I will I'll make some general comments on global developments, particularly in greenwashing as well as transnational litigation and transnational corporate accountability, as well as some comments on the phenomenon of investor-state dispute settlement, which Mr. Toby Landau, King's Counsel, has actually made some comments, and I believe the first day of this particular summit, and that's an underexplored issue when it comes to the just transition, as well as the problems with international investment law and investor-state dispute settlement. Janet will then talk about ESG obligations, including directors' duties and latest developments that directors and corporations should be aware of, particularly in light of newly issued policies on climate risk management, as well as the National Sustainability Framework and other relevant regulations. Jia Yao will be speaking about Malaysia's draft National Action Plan for Business and Human Rights, as well as Malaysia's Climate Framework Bill, and if time permits, also perhaps touching on the issue of SLAP lawsuits. So without further ado, I'm just going to go into my presentation and then have the session go into the various different presentations. Next slide. Okay. So, as I mentioned, I will be speaking about particular topical developments, and one very important development is on legal action on greenwashing. The other is transnational corporate litigation and different legal rules, and as I mentioned, investor-state dispute settlement. And just to provide an overview of various legal actions on greenwashing. So it's important to note that a lot of greenwashing-based litigation and legal risk is not necessarily based on new laws regarding greenwashing. It is really based simply on the established principle that claims that are made regarding, let's say, an investment product, investment fund, or a certain aspect of a company's business have to be accurate. So it's not necessarily something that is groundbreaking. Making claims about the environmental nature or sustainability credentials of a corporation is no different from other kinds of claims that a corporation can make. And so you see on the slide, there are different guidelines that are relating to greenwashing. So that is in the circle on the slide. You would have, say, climate disclosure and reporting guidelines, what companies are disclosing, and for now, largely concerning listed company disclosures, but increasingly also non-listed company disclosures. You would have labeling standards, So these are requirements for product and fund labeling. So let's say what can be called an ESG fund, the nature of characterizing a particular business product. Then you can have different standards on green ratings and criteria, as well as green taxonomies, which are really a classification system for what constitute a sustainable economic activity. So those are the way things are labeled, to put it kind of a bit colloquially in the circle. And then in the rectangle, those are the relevant laws that are breached when information is misleading because it is not transmitted in a way that complies with relevant guidelines and laws. And therefore, there can be various legal grounds that arise. So for instance, penalties under consumer protection law or competition law or breach of advertising codes can also give rise to legal claims for misrepresentation to consumers as a tortious action of misrepresentation. Failure to make good on environmental warranties can give rise to breach of contractual provisions regarding those warranties. And shareholders of a financial institution or company can take action regarding misleading information provided to them. And we will shortly see an example of that also. And it's also really important to note that there can be a wide variety of stakeholders that are involved in legal action. So you could have civil litigation that's brought by private individuals and other corporate entities against each other, potentially. You could have stakeholders like NGOs that make complaints to a regulator, and I will also be touching on that shortly with respect to a complaint that ClientEarth has made to the French financial regulator. And the regulator could, of course, of its own volition, investigate and take action. So in terms of trends then, I'll just highlight a couple which are quite interesting and quite basically latest developments. The first is the phenomenon of greenwashing by offsets. So this is when a company markets a product as green, but in fact relies wholly or in material parts on the purchase of voluntary carbon credits to support the claim. So an example of that would be the case that has been brought by Dutch NGOs against KLM, and this was actually supported by ClientEarth. So in March 2024, the Dutch court ruled that KLM's claims that suggested that flying can be or is becoming sustainable, as well as advertising suggesting that its offsetting products reduce or compensate for climate impact of flying, are misleading and therefore unlawful. And the court ruled that KLM was liable for greenwashing and for breach of EU consumer law. This is the first greenwashing case worldwide to rule on claims relating to the adequacy of corporate transition plans, and it sets a legal precedent with ramifications not just across the legal aviation sector, but for all companies that are advertising their commitment to the Paris Agreement. Now, this was, of course, based on EU consumer law and also Dutch law, and so it's important for any contemplation of legal liability to then be situated in the particular country in question in which the company is operating. But the point, I think, remains that there's an increasing trend of scrutiny in this fashion, and that there can be examples from other jurisdictions which can give rise or inspire similar litigation in the jurisdiction in which the company is operating. The other example that I would like to give is with respect to regulatory complaints. So this is also a growing trend. And in this respect, the example here is with respect to ClientEarth's complaint to the French regulator on purported mislabeling by BlackRock of its investment funds. So basically, fund and product greenwashing is where funds and products are labeled as green when the product is only partially green or the green attributes are not a significant aspect of the overall environmental impact of the product. So in this case, with BlackRock, ClientEarth filed a complaint regarding 18 of BlackRock's actively managed retail investment funds marketed in France. And the basis was that the fund includes the term sustainable in their fund names. And ClientEarth contends that this is greenwashing, as each fund has material exposure to fossil fuel companies that are developing new fossil fuel projects or capacity, and or not phasing out fossil fuel production consistently with the Paris Agreement's temperature goals. And collectively, these funds are allegedly exposed to more than US $1 billion of fossil fuel investment, the vast majority of which is in fossil fuel developers. So the ClientEarth has a complaint which has made public on its website if you'd like to check it. It has a detailed analysis of the various laws, regulations, and fund details, and particularly how the terminology of sustainability sustainability, implies consistency with Paris Agreement temperature goals, and how this is connected to climate change mitigation, Paris-aligned emissions reductions, and what it means to be sustainable as recognized in financial and corporate law. So this has implications, hopefully in the future, for how a fund would present its connection to the fossil fuel sector, as well as investment in it. So I think there's also the third trend to also take note of is that there's increasement involvement by regulators in Asia on the issue of greenwashing. So I've put down an example there on action that the Ministry of Environment of South Korea has taken with respect to the company POSCO. So a complaint was raised in July 2024 by a climate advocacy charity, Solutions for Our Climate, against POSCO because POSCO had purportedly misleadingly promoted its steel products as low carbon when they were in fact produced in a carbon-intensive manner. The ministry took action and requested POSCO to correct this misleading advertisement, and POSCO complied. So we see here also that there is an increasing trend in Asia for regulators to get involved, and it remains to be seen how this would continue in the future. The fourth trend to take note of is so-called commercial greenwashing cases that can be subject to litigation or arbitration. So I had previously mentioned the issue of environmental warranties and breach of contract. So that could even be warranties as between companies with respect to a project development or different forms of infrastructure or a joint venture, and that itself could give rise to litigation. So this is not, say, NGO-led litigation. It is part and parcel of how the climate change and environmental protection is now becoming very much part of normal corporate discourse, and how it's very important now for directors and corporations to take note of that, because it could give rise to so-called plain vanilla commercial disputes. And you will hear more later from Janet, I think, on directors' duties generally on ESG. And that I think this deals with the fifth trend I put there on directors' duties. And is there now an obligation to ensure that greenwashing does not occur? So this could be the next development. So other recent climate litigation against companies, I'm just going to go quite briefly because that's taken up quite a lot of time already. So one interesting case is the case of Asmania versus Holcim that was brought in the Swiss court. And that was interesting because it's basically an example of transnational corporate litigation. Indonesian islanders from the island of Pari sued Holcim in French courts. That's where Holcim is incorporated, so in Swiss courts, under the Swiss Civil Code for climate change impacts that Holcim had actually caused, which they alleged that these climate change impacts caused flooding in the Indonesian island of Pari. So whether or not they'll succeed or not, it remains to be seen, but it's quite interesting because the breach that's alleged is a breach of Swiss law against a Swiss incorporated company for effects in Indonesia. So we'll see how that develops. The other case that's interesting is in Japan, how for the first time there has been a youth-led civil climate case against a number of thermal power companies in Japan. And this is on the basis of Japanese tort law, but with reference to the Japanese constitution. So Japanese tort law that requires the protection of the youth plaintiffs' extremely important rights or interests, including their right to life, health, and property. And these rights are then rights in the Japanese constitution. So for the lawyers in this room, a very interesting mix of a claim that is brought as a matter of tort law, but referencing Japanese constitutional rights. And this case is currently pending. Next one. So basically, the director's duties are increasing across. Oh, okay, sorry, anyway, let's move on to the next slide. Okay, so basically, I'll just very quickly go on to this issue of investor-state dispute settlement. I think that this has been quite an underlooked area. Basically, 85% of ASEAN investment treaties do not include provisions on sustainable development, which means that there is a disjunct between the way the Paris Agreement and international environmental law and international climate law is developing, as contrasted with protection of foreign investors, which may not necessarily allow for flexibility for a country to make the necessary policy or regulatory changes, because if they make changes to their regulations or policies, they could potentially expose themselves to a lawsuit from foreign investors for interfering with their investments. And this is a situation which has not really been looked at closely by the international arbitration community. So lawyers are sometimes not the most flexible and reactive of people, especially when it hurts their bottom line. But this is a problem because, as you can see from this, what the UN Special Rapporteur on Human Rights and the Environment has stated, the ISDS system is very much out of line with concepts of just transition as well as international environmental protection. And I can go into this a bit more in the question and answers because I am badly running out of time. And I think this is quite a good example, as you see from the slide here, about another aspect of ISDS which is not often raised, which is the complete lack of involvement of local communities. So in essence, in this particular case, which was brought by a company against the Romanian government, there was very bad impacts of mining, which had actually resulted in environmental damage and harm and loss to the local communities. But when the local communities tried to basically provide submissions in the arbitral proceedings relating to this particular project, the arbitrators only allowed the local communities very limited grounds of providing submissions, and basically this demonstrated that this particular framework does not cater to hearing from local voices, which are the ones which are actually impacted. I can provide details of this a bit later, so I'm just a bit mindful of time. So anyone who wants to ask me, I can give you much more detail on this. Okay. So ClientEarth has done quite a lot of advocacy on this. So we've made submissions to the UN Special Rapporteur on Human Rights, as well as in relation to OECD's work on investment agreements and climate change. So this is one resource which I can also point you to after the session. And finally, with respect to resources, ClientEarth has also put out guides on climate action for boards in Southeast Asia, greenwashing, as well as on guardrails to address greenwashing of climate transition finance. I think we are particularly proud of the work that we have done on climate action for boards in Southeast Asia, which was actually launched together with Climate Governance Malaysia and Earth on Board. And this provides various content on climate-related developments and legal risks in Southeast Asia, as well as various litigation against corporations. And some of the cases that I mentioned earlier are covered in this. So without further ado, I just want to close my brief presentation here and hand the time over to Janet, and I will be very happy to take questions later during the panel discussion. Thank you.
Thank you very much, Elizabeth. As always, very inspiring. She is a very committed advocate for the environment and for sustainability. So thank you, Elizabeth, for all that you do. I'm Janet Looi, and I'm a co-head of the ESG practice group at Skrine, so I'm a practicing lawyer. I'm also a corporate M&A lawyer, and this is where I come to be to talk about this topic. So in terms of ESG frameworks, there have been many ESG frameworks. Our regulators in Malaysia, we should be very proud of them. They are ahead of the curve, I would say, in this region. And all of them have come up with the different frameworks, from Bank Negara to SC to SC, as well as Bursa. And with regards to SC, the latest development is something we should take into account, the National Sustainability Reporting Framework, the NSRF. This was issued in September 2024, and those of you who were at the keynote yesterday would have heard Datuk Faiz Asmi, the SC chairman, talk about the NSRF. And it really is important because it makes things mandatory. And it's not just about reporting, and I'll go into that later. The connection between reporting and corporate governance is really the key here. So the NSRF is intended to move companies towards a global common global language for sustainability reporting. And it is a framework to improve transparency, accountability, and data availability on key sustainability matters. It uses the IFRS Sustainability Disclosure Standards issued by the ISSB, and this would be IFRS S1, as you may have heard in other sessions, that's the sustainability-related financial information, and IFRS S2, climate-related disclosures. And in terms of timeline, when it will become mandatory for companies, this will stretch from the main market listers with market cap of 2 billion and above from 2025, and then it will go right through to 2027 for the other non-listed entities who are not in Group 1 and Group 2, and will also include non-listed companies with annual revenue of 2 billion and above. I do not want to go into technicalities on the IFRS because I am not an accountant, but I want to emphasize why it's important that the IFRS S2 in the context of climate, why that is important to more than just a reporting obligation. The IFRS S2 requires an entity to disclose information about climate-related risks and opportunities that could reasonably be expected to affect the entity's cash flows, its access to finance or cost of capital over the short, medium, or long term. And so it also goes into a requirement for an entity to disclose information that enables general users to understand not just its financial systems, but its governance processes, controls and procedures that the entity uses to monitor, manage, and oversee climate-related risks and opportunities, the entity's strategy for managing climate-related risks and opportunities, and the processes the entity uses to identify, assess, prioritize, and monitor climate-related risks and opportunities, including, importantly, whether or not the processes are integrated into and inform the entity's overall risk management process. So very often we talk about these standards as just reporting standards, but why they are being emphasized is to make sure that within the organization, the governance element is the single most important factor, so that you have allocation of responsibility and checks and controls throughout the plan for decarbonization, for instance. The decarbonization targets within the plans and the whole overall approach to this are also important for things like financing. Transition finance, you would need to be able to disclose a credible plan for this, and also you need to be able to prepare for things like CBAM. So it is a process which is an overall entity process, starting from the top down to management and to the entire organization. Now, the SC has for many, many years already had the Malaysian Code of Corporate Governance, and it is very clear. The SC has made this very clear through the code that the board is collectively responsible for the long-term success of a company and delivery of sustainable value to the shareholders. When it discharges its fiduciary duties, it's imperative for the board to set the strategic direction of the company while exercising oversight and management. And so the code also, then, as I said, for many years has applied this. This is already something that listed companies are familiar with, require the integration of sustainability considerations in corporate strategy. And Bursa Malaysia has also, in terms of the NSRF, also amended the listing requirements in line with the timelines I mentioned earlier. BNM has also issued, just earlier this year, a new climate risk management policy, 2025, which also aligns timelines along the similar lines as the NSRF. And what this means is that directors have to pay attention to this for the companies because it will affect the way in which financiers agree to finance or indeed not to finance companies' projects. Moving on to directors' duties. As you know, directors have a fiduciary duty to act in the best interest of the company. So it's no longer in doubt, and there are many, many legal opinions, and the regulators are also in line with this, and the Malaysian regulators have said this very clearly. Directors are required to take into account climate risks in their decision-making on strategies and policies of the company. Hence, when you have something like the IFRS 2 requirements, it forces the boards to drill down into considerations that are required in order for the directors to properly discharge their duties. And how do they do that? They do that firstly by looking at impacts of the business activities on the environment and social systems. They do that by assessment of what sustainability risks are and the financial implications to the business. They do that by measurement and disclosure of material risks and opportunities on balance sheets and profits and cash flow. They have to also review risks, and this includes regulatory risks, liability risks from sustainability disclosure and financial statements, going to greenwashing, as Elizabeth has mentioned to you. And climate litigation is also a risk, as Elizabeth has also enlightened us on. And of course, they have to look at opportunities such as green technologies and carbon markets. All of this requires governance controls and a demand by boards that sustainability risks are baked into each proposal presented by the management to the board. So it's very important that the board is not caught up in an echo chamber of just relying on management. They have to question and they have to really ask, and this is how they discharge their duties. So based on the Petropadana subjective and objective tests in the federal court case, the foreseeable risks of climate change must be taken into account by directors. And there is no doubt about that. So for this item not to be on the agenda today on board meetings is actually leading the board into risks and also the company. Ignoring this, despite the scientific and physical impacts of climate change, would subject directors to be guilty of, and the cases have used this term, willful blindness, or a mere centennial who occasionally dozes off at this post. So it is no longer acceptable, and this is very, very clear from case law and many legal opinions around the world. The role of institutional investors is also another pressuring leverage that will be placed on companies. So boards also have to manage investor and stakeholder expectations as part of their discharge of their duties. And regulators such as SC have also taken action against fund managers for failing their duties and breaching securities laws. And in this regard, what Elizabeth said earlier about misrepresentation in your financial statements and your disclosures for your capital markets products will be examples of where the regulators are able to take action. And this has already happened in other jurisdictions, and it will no doubt be something that the SC will be looking at in the very near future. The Malaysian Code for Institutional Investors, also for your information, apply or explain approach, and states that institutional investors should seek comprehensive, transparent, and accurate sustainability disclosures from investee companies. So the pressure is on from many angles, but for a good reason. In terms of other, what we would call soft law, that would have an effect on liability for companies and directors. One example is the case of Muhammad Khairul Anwar and the Associated Pan Malaysian Cement. The court actually held there that the employer failed in CSR in safeguarding the interests of workers, and that they have a moral and social commitment to do so by reference to the UNGPs. And this is interesting because the UNGPs were not enacted into law, and yet the court made reference to it. This is why we call it soft law. And so for the courts to be taking this kind of judicial notice, this means to say that attention has to be paid also to these guiding principles as best practices, at the very least, within an organization. Also, as Malaysia is signatory to the Paris Agreement, one should pay heed to the statement by the judge in Nur Fadilah and Chayat, where the judge said, it is the court's duty to take into account the government commitment and obligation at international level in interpreting the constitutional rights, such as Article 8.2 of the Federal Constitution on the right to equality, emphasizing commitments under international conventions, such as the Convention on Elimination of All Forms of Discrimination. And Chief Justice Tunku Maimun also recently said that the judiciary remains instrumental in moving the SDG 16 aspirations, and thus it can be expected that the judges would also look at SDG 13 relating to climate action. So this gives you a flavor of where the direction of judicial approach will be for future cases. I would like to just sort of round up this discussion by telling you about two other aspects where there could be liability on the part of companies. In this federal court case in 2020, and this is not new, this is just a new case, but the principle of lifting a corporate veil is not new. The court said that the court may lift the corporate veil where the relationship between the companies is so intertwined that they may be treated as a single entity to reflect the economic and commercial realities of the situation, so that the parent is liable for the acts of its subsidiary. So this is something that is really important from an environmental and sustainability risk perspective, how you manage. So each of the subsidiaries has a board. The boards have to make their own decisions, whether the actions are in the best interest of the company, and not just rely on the parent. And last but not least, there is this case in the UK Supreme Courts of Okapi and Vedanta, where I will just inform you as to the judgment by the UK Supreme Court vis-a-vis Vedanta's annual report, and where it held that Vedanta's annual report and public statements indicate representations made by the board and the company to its members, investors, and third parties that could be relevant in determining whether a duty of care exists. And this was affirmed in the case of Okapi and Royal Dutch Shell. And so, as you know, then, this will be highly persuasive in the Malaysian Court of Law, since this is from the UK courts, common law courts. And I will wrap up by just saying that for a board and for companies, there are many, many factors that you have to take into account. It is not as scary or difficult as it may look when you have a whole mirage there. All of it can be solved by having a high-level strategy and action plans that take into consideration all of these factors. And I know that I'm probably now out of my time. I thank you very much for your kind attention. Thank you, and happy to take questions afterwards. Thank you so much.
Good afternoon, everyone, and it's a pleasure to be here. Thank you very much, and fascinating. I hope I could give more time to Elizabeth and to Janet to go on some more, actually. I will be sharing in my time some legal developments around, I think, two pieces of emerging soft and hard law. The first one will be on the National Action Plan for Business and Human Rights, the NAP-BHR, which is in zero draft form right now and evolving. The second one will be on the Climate Change Act that also is in draft process now, but hurriedly being moved forward. And if we have time, which I probably would hold back, we might talk about strategic lawsuits against public participation. But let's focus on the two. On to the NAP-BHR. First, what is it? So this is not law. This is it's a national action plan. It's a policy instrument, you could say. It's going to be Malaysia's policy, official policy on business and human rights. So a little bit of history on this would be the business and human rights, BHR, as a concept. You'd be familiar with human rights from very much human rights is the responsibility of governments to take care and to protect. But there has been, for a long time, evolution of this expectation for human rights to also have something to do with the private sector, with business actors. And that has evolved over time. into the Human Rights Security Council in 2011, passing the UNGP, the United Nations Guiding Principles on Business and Human Rights, which has been referred to in the Malaysian court, that, as Janet has interestingly pointed out. So UNGP has got three basic pillars. Essentially, it says that the state, the government, has the responsibility to protect human rights within the country. The second pillar is the business community has the responsibility to respect human rights. So, and then the third one is about that there should be access to remedy. So 3 key pillars with 3 R's. Yeah. So sorry, not 3 R's, right? There's a protect, and then there's a respect, and then there's remedies. So the National Action Plan incorporates the UNGP, these 3 pillars. The same is anchored on that, but it does it in the context of Malaysia. So this has been, so who's involved in spearheading this? This Malaysian government, the cabinet approved, committed to this in 2019 in a decision by cabinet. So Malaysia is very much committed to the UN, to bringing the UNGP down into domestic level, so that we too want to show that we are a civilized country, and it is good for, of course, development domestically. So. It's spearheaded by the Prime Minister's Department, specifically the Bahagian Hal Ehwal Undang-Undang, or referred to as BAYU, and together in collaboration with Suhakam, as well as the United Nations Development Programme, which is the UN agency that supports this sort of business and human rights is a particularly important agenda. Now, the draft has been a long time coming, but now with Dato Azlina helming the Law Ministry, she's committed that the NAP will come into fruition and completion. She said earlier the first quarter of this year. So we've seen the zero draft, and the zero draft consultation period had come to an end in February. So next, there's going to be some iterative process in which all the stakeholders consultation. Has anyone provided feedback on the NAP BHR? Excellent, fantastic. So you can see my optimism level is very low. It's just 2 hands. I'm very delighted already. But the fact is, it's a full room, so I'm encouraged. But yeah, they're going to iterate, and a lot of input have been collected. I understand during this process. So the draft will be moving along. So next slide, please. And so inside it, it's important to just remember that it's a 5-year plan. It's for 2025 to 2030. So it's pretty much in line with all our Malaysian plans as well. And it coincides conveniently with the Sustainable Development Goals, which also comes to an end by 2030. And so business and human rights is a key piece, actually, towards sustainable development. And it's a fundamental, a very profound shift. It has a few thematic priorities. So the priorities, these thematic priorities did not just come out of thin air. They were built based on a 2 to 3 year exercise of a national baseline assessment exercise that's been done through a lot of consultation with our business sector. And so that's basically an assessment of the state of where we are in terms of Malaysian businesses, the private sector, our economy, our institutions, and human rights. Yeah. Essentially, the assessment was, as what everyone would expect. It really shows a very nascent or very, very low level of awareness around human rights and what it has to do with businesses and what their role is. And so we've got a lot of work to do, and that's hopefully going to be reflected in the recommendations according to themes. So there are three or 3.5 main themes under this. There's a governance, labor, and environmental, and then you got special issues because they can't put them into convenient, neat little pigeonholes because life is such. Yeah, you will see. As under governance, it really goes as deep as the foundations of rule of law, democracy, enforcement of laws, anti-corruption, bribery, that kind of issues. That's under that thematic priority. labor, there's forced labor, there's child labor, social protection, right of people to form unions and come together and associate with each other, their grievance mechanisms and remedies. Under the environment, it's about environmental governance, it's about transparency to information, about access to justice and environmental justice, it's about forest management, it's about pollution, and waste management, it's plastic circularity, climate change, of course, and specific issues. And they're not there because they're not important, but they're there because a lot of them are actually integrate across all the other themes: gender, children's rights, the rights of indigenous peoples, refugees, asylum seekers, these other people who don't fall into citizen categories, for example. Digital rights as well, which is also another paradigm that's emerging. Extraterritorial obligations, for example, like transboundary haze, and strategic lawsuits against public participation. So undemocratic practices. So now the government actions, and then so they are under the draft National Action Plan and BHR. There are actions, well, it's an action plan, yeah, so it's very action-oriented. So there are actions for the government, and then there are actions for the private sector. So before your eyes dance over to the private side, let's look at the government side, because that will inform what will happen more on the private sector side. Yeah, you'll probably jump down to the so what at the end already. So, yeah. But I think it's important to understand this is an iterative process. We are all on together, although it's just two of you who have participated in it, but together. So what is the government expected to do under the draft? This is just draft, zero draft. They call it zero draft. So when draft version 1 comes out, it could be substantially different. We don't know. Yeah. So the government actions here would be generally strengthening the legal and regulatory frameworks across many sectors and areas, improving enforcement mechanisms. We often hear this usual refrain: "Oh, we got nice laws, but we don't have enforcement muscle." An important aspect is promoting policy coherence. We have lots of policies, but they don't interface with each other, which is a problem that continues to happen, right? So we just pursued the CCUS without regard for our climate change, a national climate change policy, for example, or is not appearing in under our climate change supposed to be framework law, which I'll discuss shortly. So policy coherence is really important, so that, well, we don't waste our time and we don't waste our resources and energy. That's about accessing, access to remedy. So access to information, which is the first thing you can before you can build a case and actually articulate who's responsible for the misery that you have suffered or a problem. So access to remedy, access to justice. Institutions need to be less and less discriminatory, so that more and more people can have a chance of bringing their grievances forward and to be heard justly. So then there's a lot to do with public awareness and capacity building, having the capacity to hear and then to receive the grievances, the complaints, the feedback, all the engagement that comes, right? So without capacity, all this is noise, and noise is, of course, destined to be filtered out. So kind of like the noise that the residents of Putra Heights complained about. That was deemed noise, not enough action, didn't escalate fast enough, and so yeah. So so it's about how do we become better as a more intelligent society. So enacting Freedom of Information Act. So another common refrain you would hear, especially around policymakers, would be access to data is a pain. It's a real pain point. It's like it's like depriving oxygen to a brain. So there's no information and there's no analyses to be had. So that's on government actions, all fundamental stuff. So private sector actions is for, now, in the private sector actors, developing and implementing human rights policies. So we're seeing the listed companies, the big players that especially have overseas reach, already have a lot of pretty sophisticated human rights policies, conducting human rights due diligence. Quite a number of businesses, the main player, the large players are already involved in this. of course, they're still figuring out how to improve that and make that more impactful. Now, integrating human rights into business operations. These are the directions. Yeah, engaging more with stakeholders, developing that capacity and that bandwidth to engage with stakeholders, converting the pings and the noise into intelligible and into data that you can process and analyze and make sense of, and then make cogent decisions. As directors have to do, cogent decisions and making sense of reality moment to moment. That's really tricky. So these are all things that go into that black box where you make decisions, yeah, and then and manage the business. So it's very operational focused. Of course, there's an emphasis on supporting SMEs, right? So we know the backbone of economy are SMEs, MSMEs, so a lot of what we're talking about in terms of sustainability reporting, sustainability progress of sustainability, what it looks like, it obviously cannot be cookie cutter and are very have to be context appropriate. So and yeah, we still need to work on strengthening anti-corruption. So although ABC has been around for a good time, but that's still a serious problem. So now the key and the so what is, I guess I want to cut to the chase now. What it does is the NAP-BHR, when it becomes Malaysia's official policy, then the writing on the wall has emerged. I mean, now it has emerged. If you go to court, I'm sure you can test cases already, as how judges are already referring to UNGPs. But once you have NAP-BHR, then the writing is on the wall for everyone to see that the responsibility of business has officially shifted. Where before, businessmen can still rely on the paradigm where it's catch me if you can, suckers kind of mindset, to you now have literally the second pillar. You have the duty to respect human rights. That's baseline. That's not aspirational, that's not charity, that's not being good. It's not being good. You do not earn any brownie points for respecting human rights. This is baseline. This is the new baseline. So just now, as Janet has just shared, do not think anymore that the board seat is where you go and retire. No, this is not where you go to be lazy and then and take things for granted and be entitled and enjoy your privileges. No. Because the seat is getting hotter and hotter and hotter. So this is still soft law because it's policy, but this is just the first of the tsunami of expectations that's going to come. So let's go on and talk about the Climate Change Act on the back of this. Now, I don't know how much time I have. Maybe 5-10 minutes, okay. So right now we're in the midst of developing the Malaysia's first Climate Change Act. So we don't have any law for climate change at the moment, right? We have law to throttle and control and limit pollution, and itu pun is some aspects of pollution, all right? So everything else, especially the kind of pollution that all of us are collectively responsible for, right? There's no regulatory framework or regime for it. So this has been long overdue, and so and I would, at the end of it, I think I jumped to my reflections. I think this is a catch-up type of legislation, all right? And I will explain a little bit about why this is actually a catch-up instead of a climate leadership type of thing, and then what that means to you, all right? So the background here is, well, Malaysia, again, eager not to be a pariah country. We have to meet our international obligations as a developing country in playing our part in combating climate change. And so we're participating in that, right? So UNFCCC, Paris Agreement, we're all part of that process. We submit our NDCs. We're committed to developing our adaptation frameworks and then our LT-LEDs, etc. All right, so the NRES ministry has been pushing this. And it's been doing a lot in terms of doing it and developing the Climate Change Act, the draft act, in a consultative manner. And I think as consultatively as NRES has been able to do. So credit to them. Now, the last round of consultation, well, actually it's one round of consultation. It's a consultation paper that was issued on 4th of October last year. They gave 6 weeks for everyone to, well, they gave it 4 weeks and then they extended for 2 weeks. So by 18th, yeah, by around the 18th of November, then consultation was over. Now, what's in the bill, right? So what's the objective of this? It's not a bill yet because it's not been tabled in Parliament, yeah? So it's still a draft. So the key part of it is ostensibly what is stated in the consultative paper, which you can still download if you go to NRES website. And do have a look at it, Has anyone downloaded the NRES consultative panel? Consultation paper? Yes, great, excellent, great, excellent, right? So you've actually looked at it. It's not a difficult read. It's very few pages, and it's very repetitive and doesn't say much. All right. All right. It's a summary of a summary of a summary. So it's very easy to read. You can read it while watching Severance. So it sets first thing it does is it gives the ministry, in this case NRES, the power to do the things that Malaysia needs to do to meet our international commitments. All right? So that's the first focus and the primary focus. Then it aspires to be the umbrella legislation for all things climate change in Malaysia. All right? That's the breadth of it. Whole of nation, right? That means state governments as well. It will set Malaysia's climate agenda. It will implement mitigation and adaptation. So for those not too familiar with climate change, addressing climate change, there's mitigation is the code word for cutting greenhouse emissions. So, right, that's called mitigation. That means all things relating to like cutting our reliance on fossil fuels, right? Our transportations that produces a lot of emissions. So that's on the mitigation side of things. And then there's the adaptation. Adaptation refers to dealing with the adverse impacts of climate change, all right? So building up resilience, right? So thinking about our infrastructure, thinking about our local communities, thinking about our disaster response, etc. And also thinking about development today that's not going to heighten our risk for in the light of the impacts of climate change. So the draft inside there, the draft act will cover, and this is from the consultation paper. It says it will cover, it will give the minister all the powers that he or she in the future will need for meeting all our international commitments under the Paris Agreement. So next page, please. All right. It also sets up it establishes this regulatory entity. So a new entity will emerge with regards to climate change issues, but it's going to be parked under NRES. And then you will also establish a data, so they call it a National Integrated Data Repository for Climate Change, also under NRES. All right, so that's on all the sustainability data. I don't know if all, the Bursa data, the SE's data, the states, the Sarawak data, is that all going to come in here, right? Well, it should not, because then we are reporting internationally, right? So it has to be. Oh, I need to wrap up. So now, let me jump straight to my observations, all right? My observations are that it is unfortunate that the championing, who's at the tip of the spear is the NRES minister, it's not the prime minister. So without that leadership from the top, we are not getting the all-of-government approach. And then, therefore, we won't get an all-of-nation approach. So NRES is struggling in negotiating with its peer ministries and the other ministries. And that Taikon ministries, no need to say, Ministry of Economy, Ministry of Finance, is going to challenge, right? So Petra, for example, has been split out from Nick Nazmi's ministry. Now, so what the reality of that is the constraints of which the Climate Change Act is being drafted. It is being drafted to ensure that the act is has to stay within NRES's lane. Now, the result of that, the upshot of that, is the contortion of climate change issues into issues that NRES can touch or have soft influence on. And then the neglecting of other things that NRES cannot touch. For example, that important pillar, I said, mitigation and adaptation. All of adaptation, NRES has dropped. So adaptation doesn't happen inside our Climate Change Act, all right? So not in a meaningful way, all right? Not in a meaningful way. The minister says, hey, we're gonna rely largely, we're gonna lean on the adaptation policy that we are working on, hopefully out next year. So okay, lots of issues, but we can discuss some more. I better hand it back over to Elizabeth. Thank you so much.
Thank you, Jia Yao, and sorry to rush you. And of course, please feel to approach any of us if you have any questions. We have the panel discussion, but probably we'll have time for a lot of questions. I'd just like to introduce now our next surprise speaker. I'd like to introduce Mr. Abdul Hafiz bin Muhammad Hatta. He is the Principal Assistant Director of the Consumerism Research and Policy Division of the Ministry of Domestic Trade and Cost of Living, and he will speak on the regulatory framework on greenwashing in Malaysia and the work done by the Ministry on greenwashing as well as future developments. So without further ado, Mr. Abdul.
Thank you, Elizabeth, for having me here today. How are you guys? I'm not going to take much of your time. So what I'm going to present to you today is about combating greenwashing in Malaysia from a consumerism perspective. Yeah. All right. Next. Okay. Malaysia tackles greenwashing by primarily through existing consumer protection laws rather than having a specific regulations on it. As companies increasingly make environmental claims, that regulatory framework has evolved to address false or misleading representations that could deceive consumer about environmental benefits. So in today's presentation, we will look at those regulatory and what is way forward that the government is the actions that the government is going to take. Yeah. All right. Next. Okay. From a consumerism perspective, to combat greenwashing, we don't have a specific terms under our acts that stated greenwashing, but we do have, it falls under Consumer Protection Act 1999, and we do combat it through this Trade Description Act 2011, primary legislation addressing greenwashing through Section 9 and 10, which prohibit misleading conduct and false representation about goods and services. So the general application of this act, well, I did mention earlier that we don't have the specific terms about greenwashing in our acts, but it covers environmental claims under broader consumer protection provisions. At the same time, we do have a self-regulations through Advertising Standard Authority, which ASA provide guideline for environmental claims in Part 11 of their Malaysian Conduct of Advertising Practice. So Malaysians approach, our approach combines statutory regulations through the CPA and TDA with industry self-regulations via ASA Code of Conduct, while the CPA will look at the legal enforcement mechanism with penalties or for violations, but ASA is more on the self-regulate for the companies, for the industries, so that they might take a careful claim about their the environmental claims about their products or businesses. Yeah. Next. So from the regulatory scope, we use a broad consumer protection versus specific greenwashing rules. Under the CPA, we focus on the broader approach, where it's covering greenwashing under general provisions. I did mention earlier, it's stated under our section 12 and 13. It's stated clearly what is meant by the false or mislead advertisement. So greenwashing, based on the definition, I'm sure whether up until now we don't have a very specific definition of about greenwashing. So it falls under, because of that, we falls under the CPA 1999 and the TDA 2011 is about the mislead advertisement that been advertised by the companies about their businesses or about their services. Yeah. All right, and then we do have advertising standard, a code of conduct is under ASA. So the guidelines specifically address environmental claims, yeah, requiring them to be clear, qualified and substantiated. And then rules number 2 explicitly prohibit terms like environmentally friendly without evidence directly targeting greenwashing practices. So we do have two dual system in Malaysia right now. We do have through the Act, and the other one is through the Code of Conduct, which is more or less is a voluntary for the businesses to comply with the Code of Conduct. All right. So the mechanism, we do have government actions, and at the same time we do have a consumer recourse. So from the government enforcement, we do have Act under CPA 1999. The of Consumer Affairs KPDN serve as primary enforcement agency. We do have enforcement agency under KPDN. Which regulate if we find a breach under that Act, so we can have take a penalties, include fines up to 100,000 ringgit or imprisonment for up to 3 years for violations. We do we also can use our descriptive trade for the businesses if their businesses breach what they advertise about their business or business or yeah. So then we look at the consumer actions. Consumer can lodge complaints with KPDN if or refer disputes to the Tribunal for Consumer Claims Malaysia. So tribunal jurisdictions cover claim up to 50,000 ringgit Malaysia as amended in 2019. And then for industry, we do have a safe regulations through ASA. ASA will investigate complaints about misleading environmental claims in advertising, and can require the advertiser to withdraw or modify ads, but we don't have. They don't have a legal act, legal penalties on it. Yeah. So the impact on consumer and markets. When we talk about greenwashing, we do have 4 main impact. So it will mislead the consumer, and then it will create unfair competitions, because if you make a claim, we can't deny that the awareness about the greenwashing is getting better and better every day. So so if the businesses or services or the companies, if they make a false advertisement regarding their environmental products or services, it will create an unfair competitions. So this based on our Act and based on the complaints from the consumer, so we can take action based on those acts. So it will erode the trust and environmentally harm to our environment. So what is the future actions? So right now, under Ministry of Trade and Cost of Living, we are reviving our national consumer policy. So we will rebrand it to National Consumer Policy 2.0. So this policy has been established in, has been established in 2002 and has not been revised up until now. So right now we are revising the policy. So it's in the pipeline for it will bring this new policy to the cabinet and hope it will be endorsed by the cabinet. I don't know, maybe 2 or 3 months from now. So it'll be launched by hopefully by the Prime Minister. So what we have under this new policy? As we know that the environmental is quite the sustainable consumerism is pretty is high demand right now. So right now it's under this new, it's not a new policy. Under this policy, we do have 5 pillars. So one of the pillars is about the sustainable consumerism. So under these pillars, we will focus on green or sustainable things. And then to support this policy, actually, we are going to have a national action policy for national consumer policy, national action policy 2025 to 2030. So among the initiative that will be taken by the government is to make sure that greenwashing being made a priority, so that we can educate our consumer in Malaysia about these greenwashing activities. So when we talk about greenwashing, actually, we can't forget about one of the agencies that look at it. I think most of you knows about it. The Malaysian Green Tech Technology and Climate Change Corporation is under NRES. So we are with them to ensure that our consumers being protected under from these greenwashing activities. The national consumer policy is on the importance of cultivating sustainable consumption across all layers of human activities. I think more or less that's the regulatory framework that we have right now, especially in protecting our consumer in Malaysia regarding the greenwashing activities. I think that's all. Thank you very much for your time.
Okay, thank you so much, Mr. Abdul. Can we have a round of applause for all our presenters, Janet, Diayo, and Abdul? So without further ado, I think we're going to start the question and answer session now. Bit makeshift, I hope you don't mind, but we will pull up some chairs, get started. Please have a think about what hard questions you want to ask all the presenters. Janet, please. Okay, anyone want to kick us off? Any questions? Yes.
All right, it's working, right? Okay. First of all, thank you to all the presenters for the excellent sharing. My question is actually to Janet, and this is pertaining director's duty. Yeah, it's been said a couple of times by the presenters that director's duty is becoming hot and hot. Yeah, the word was exactly used by just now. And in terms of reporting, because when we see the reporting for sustainability under the NSRF is becoming is mandated, is already rolled out for the PLCs and eventually the other groups as well. Now, like we see some of the jurisdiction, like Australia, now they have actually introduced this what we call safe harbor, right? This is in regards to especially when you have scope 1, scope 2, and scope 3. Scope 3 is which be not within the company, beyond them. So do you think, what are your thoughts? Is it appropriate, or should Malaysia also consider of having those kind of safe harbor kind of provision in the laws to just to actually to make sure the directors, because right now we already seeing some of the companies already having some challenge of getting people on the board. Yeah. So as we know, law is evolving and liabilities are becoming stringent and stringent. So that thanks.
Thank you for that question. So in fact, I don't know whether you were there at yesterday's or rather Monday's opening session, but it was mentioned as part of Dr. Faiz's comment. And to answer your question, whether or not a safe harbor concept should be included, I mean, I think it's fair to have that, because it does take time for the systems to be in place for effectively what is a very thorough due diligence on your own company, quite frankly. So at the moment, the boards are very reliant on reports from senior management, and senior management in turn on their teams. So it is a very challenging thing. So to answer your question, I do think it's a fair thing to do. However, as you have heard at the session on Monday, it will take quite a long time to get amendments, for instance, to the Companies Act to be made to give that kind of leeway as well, because you're talking about annual financial statements as well. So it's also covered by liability under the Companies Act.
Just follow up from there. Just follow up. Yeah, because we are also talking, how do you think that that's going to balance with the greenwashing? So you see, if let's say we have this approach towards safe harbor, do you think that will actually, because we have many type of companies, we are not talking the PLC, we have large pool of the non-listed, which are, they are contributing about 98%. So eventually, if let's say these companies are also mandated under the Companies Act to actually have mandatory sustainability reporting, do you think that this will actually, in a way, contribute to greenwashing, wish-washing, or whatever? Yeah.
I am quite certain that in the way in which the provisions will be implemented, they will take into account things that are not deliberate. So if it is a deliberate act of misrepresentation that will be under your greenwashing, then that is definitely not going to come within safe harbor. I don't know what the thing will be.
Maybe I can make a comment as well as a question, because I understand there is a difference potentially between safe harbor laws and laws that pertain to misleading representations, which can come under consumer laws. You've heard Mr. Abdul talk about the regime in Malaysia. So it would appear, and just grateful to hear anyone's views, that they can actually go concurrently, right? So you could have safe harbor with respect to directors' duties and maybe reporting requirements, but the existing legislation and policy of protecting consumers would still continue to proceed, if that's what I understand from Mr. Abdul. Would you like to comment, Mr. Abdul?
Hello, yeah. All right, regarding greenwashing, I think we do have regulations and act in Malaysia. So, but as I did mention earlier in my presentations, we don't have a very specific term that cover it, but it falls under our CPA, Consumer Protection Act. So it's under sections 12 and 13 regarding the mislead or false advertisements. So for greenwashing, yes, but for safe harbor, we have to look at it.
But that's very much perspective. Now, what about the investors and any other third
Okay, I'm going to let everyone try and answer your question, okay? So, okay, without caveat, I'm not a Malaysian lawyer. I would assume that different laws apply to different categories of people, right? So, for example, for investors and institutional investors, then you have issues with respect to labeling of funds. You have the examples that I mentioned just now about the way that regulators need to look at different institutional investors labeling. There will be a specific set of rules regarding that. Then you have specific obligations that directors have in the way they run their company. That may or may not extend to an obligation to see whether the company does activity that is not labeled as greenwashing. And that is maybe the interaction between directors' duties, obligations, as well as the interface with consumers. So that would be yet another bucket, right? And then you can have, I think, just pure situations where you have laws which are not labeled within under securities laws or directors' laws, but have to do with just representations, which is just a purely tortious representation. And that can just be civil claims that are brought by private litigants. Yeah. You like?
No,
Okay.
Well, I think you've done that quite well, but do you want to add anything?
No. No, I think Elizabeth said it quite well. Yeah.
Okay, thank you. All right, any other questions?
Hi, my name is Aiman. The law school, IUM, also wearing the head of regulator, involvement in Bursa Malaysia Regulatory Committee, as well as the Malaysian Institute of Accountants. I think one of the things that we seem to forget, it's just a conversation, not a question. One thing that we seem to forget is the enforcement part. For the layman, enforcement means enforcement, but for the lawyers, it means the remedies available to the parties who's affected by the harm. So when you look at enforcement, we're talking about director's duty, Puan and Janet, talking about director's duty, sometimes we forget that when we talk about director's duty, it is the person who is going to be able to sue the directors. And so for this, you're relying on the shareholders. And there must be incentive for the shareholders to bring the suit. We have cases in Europe, VW, the announcement that they are producing cars which are EV friendly, and the backlash by the regulator because of that false announcement. And so they have been fined by the regulators, and this is a fine against the company, not necessarily against the directors. So it is then for the shareholders, perhaps institutional shareholders, ClientEarth for example, who are stakeholders in the company, to then bring an action to sue the directors for failure to prevent loss to the company. So there's a Singapore case on this point in relation to bribery and corruption, where the judges were very creative in saying that we're not saying that the director must make sure company avoid bribes in such a way, in those words, but they did say that it is the director's responsibility to minimize loss and harm to the company. So if you look at greenwashing, climate change, climate litigation, you will see there are several approaches. Some are relying on the director's duty. That means the shareholders will have to take an action. The regulators will have to step in, but it depends on the regulator's own enforcement policy. To be fair, SSM has developed very much from the day when it was just, considered as a government department, right? So when SSM, I was involved in the Companies Act law reform. It was one of the challenges to tell the regulator that they need to step up and be more than just record depository keepers. And so if you look at SSM's website, not trying to, promoting them or advertising, but there has been that change in enforcement policy. So perhaps when you talk about greenwashing, consumer protection, that enforcement policy part needs to be settled at the regulator's level.
Thank you so much for that really comprehensive comment. I would love to follow up with you later on some of the aspects you said. I'm going to just pass it first to Jia Yao and then Janet to comment, and then Ms. Abdul.
Yeah, I think that's the emerging shift in the involvement of regulators in areas of sustainability. That is in line, obviously, with the evolving role that regulators are finding themselves to play. Most of them, of course, are playing it reluctantly. They need to be dragged along. And that has been happening for decades. And so now we're seeing cases appearing and then them making decisions. So I think Elizabeth has shared, for example, around how the involvement of regulators and taking their constituents to task on where before you would think these are conventional complaints issues and they are investigating. But it's just that in the rule book, new chapters have been inserted. So this is the diffusion of the broader stakeholders' interest that is now, I don't want to use the reductive word, competing with shareholders and investors' interests. Where before in the older paradigm, before we are now mainstreaming sustainable development, let's call it the previous exploitative development paradigm, it's only shareholders' interests that is actually at the table and that is only allowed to be discussed at the table. You cannot discuss everyone else's because then it takes away from the pie. That was the previous mindset. Now they understand that now the writing is on the wall. Everyone understands there's no business to be done on a dead planet, right? And we are pushing planetary boundaries 3 times over. And so, so the chickens have come back to roost. The money men have wisened up, and so we have TCFDs. We have all these things already, and they are trickling down into every aspects of our, down to national consumer policy, into our national action plans on consumer action, consumer protection as well, and all other aspects of life. So I think that's the phenomena we're seeing.
I think the point is well made. And for shareholders, the trend is the easiest way is remove them at the next AGM, or if there is a dispute, then there needs to be removal. As far as litigation is concerned, we are more frequently seeing this after the event. So, when there's been a big event, the directors are already off, then they're sued subsequently. Then that is the trend. So as far as your comment about CCM is concerned, it's a very good comment. It will increase pressure when the CCM takes more actions on breaches of directors' duties. In the case of very blatant breaches, the lack of action sometimes could be quite glaring. And I want to make a separate point, which is the point about the business review report. At the moment, the business review report, as you know, is now voluntary. And there is something to be said, I think, about considering whether that should not be mandatory. But of course, there are many different categories of companies. But the benefit of making that mandatory then is that it clearly then ties in with this whole sustainability discussion that needs to be in the business strategy and the board strategy.
Thank you. Sorry. Maybe just before you do, I'd like to get Mr. Abdul's perspective as a regulator, and then we can go to, yes.
Yeah, thank you. Thank you, Puan Aiman. Yeah, I do agree with you that we need to step up as a regulator. If you look at our acts, especially the CPA on consumerism part, the act actually is a reactive. So when we have complaints, then the government will intervene. So right now, if I can share with you guys, last year in 2024, regarding the mislead advertisement, we are not talking about the greenwashing advertisement. We are talking about mislead and false advertisement. So the whole year in 2024 is around 2,000 complaints made by the consumer. So although you can look at from both sides, whether it's good or not. So from our side, we still feel that the advocacy programs to our consumer is still, our consumer still does not take. There's the awareness about the mislead advertisement is not there yet. So I think the advocacy programs need to be done by the government so that we are not reactive anymore. So we be proactive. So in order to be proactive, I do agree that we need to look at our CPA Act. But right now, the power that we have under that act is being reactive. But I do agree with you that we need to step up. Thank you.
Thank you. Madam, you had a question, but just very briefly so I can give other people.
Update actually to what Janet said about business review report under the Companies Act. I'm actually from CCM. Yeah, there's going to be some possible amendments to Companies Act. So we know that under the NSRF, the Group 3 companies, which are the non-listed with a revenue 2 billion above, they are already being mandated to report onwards 2027. But apart from that, for this year, we are studying the possible amendments, looking into more type of companies, probably they will be required to report mandatory. Yeah, thanks.
Thank you. Any questions? Any other questions? Okay, in that case, nothing else? Okay, in that case, I think we are just about coming to the close of this session. Let me just ask one question for all the panelists, and that's really, if you had a wish list question, like if you could see one thing that you want to achieve out of the various presentations that you have made today, as well as the comments, right? What would you want to see? And I will start with Jia Yao.
Okay, I think, so I ended on the lack of climate leadership from the government side. So I think what that means for all of us in the room is so climate leadership must come from you. So a good example would be like corporate CGM, right? Climate Governance Malaysia. It's self-organized, it's come together, building that community to make sense of what needs to be done, what are priority areas, who can do what, right? So forming your communities, so whether it's not just CGM, so if you're part of the Malay Chamber of Commerce and an industry, you're part of the business network, sectoral, subsectoral, so these nodes have a key role to play. And these nodes, these networks cannot do anything because they are largely voluntary without people volunteering for it, like Janet volunteering for CGM and etc. Right? So yeah, basically we all make up the fabric of society. So I think more people take up that civic aspect of playing a role, however small you think it would be, but it's contextual and it's very relevant. Thanks.
All right. I think one thing that I want to see here in Malaysia, especially when you are from Ministry of KPDN, so I would like to see that our consumers have been empowered, so they know their rules and their rights, which at this moment we still have. We do have a CI Consumer Empowerment Index, but we did that index in 2020, so the consumer empowerment level in Malaysia is still at the 62.1%. So I hope that if our consumer is being empowered, so they know their rules, so it will become the force that can promote the greenwashing activities and so on. So we can well, at least have something, the third force, for instance. Yeah, thank you.
And on my part, I agree with everything that has been said. But specifically for Malaysia, I think we should emphasize biodiversity protection. I think there's been not enough actually said about that. We talk very generally about sustainability. It would be my wish that, you know, both at the corporation and government level, we really push that agenda upwards and really do something that will be win-win for, you know, Malaysia as planet Earth and also for all the citizens of Malaysia.
Thank you so much. And just to add to what Janet said, there are actually currently discussions on directors' duties with respect to nature. So if you see in the UK, there have been legal opinions on that. There have also been some cases around the world. And so that's potentially the next iteration, moving on from climate change to looking at nature. And also to consider the link between parent company and subsidiary company liability. So when you think about that in connection to climate change as well as nature protection, so subsidiaries operating in areas or jurisdictions which require nature protection, and the link that parent companies have to assume that duty, not just piercing the corporate veil, but just as a normal course of business, then that can potentially create some interesting legal levers and legal situations. So I think just maybe we have a round of applause for our excellent panel. And thank you so much to you. You've been a wonderful audience. It's so great. And please, very happy to connect with anyone. And thank you very much for your time and attention. Have a good day.